Nope, nothing starts here at 9:30 ever. That's okay. All right, sir. I'll recall, obviously, the bond forfeiture. And so, Mr. Van Wright, you were previously in court and entered pleas of true in a motion to revoke your probation and entered plea of guilty in the new offense. Can you send me that paperwork just because this is all... And the agreement was for a 2 years TDC, and I gave you a little bit of time to come back and be sentenced today, correct? Were you arrested for anything between that time and now? So if they were agreed, I should have these printed out. We shouldn't have these if they were agreed. There they are. Put that away. All right, and give me just a second. Sorry, I'm a little out of sorts. What did he plead true to?
There's only one count.
Judge accepted the plea, then delivered the sentence. 2 years in prison, probation revoked, and no right to appeal.
And then change it. Got it. All right, Mr. Van Wright, in cause number 24 DCCR 2485, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 15-23582, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find sufficient evidence in that case to revoke your probation, and at this time, revoke your probation and reassess your punishment in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that for any time that you've been in custody that the law gives you the right to receive. The cases will run concurrently, which means together.
This moment is critical, and it's one a lot of defendants don't fully grasp until it's over. When the judge says these sentences will run concurrently, that means both 2-year sentences are served at the same time, not back-to-back. But here's the trade-off. This was a negotiated agreement. By accepting it, the defendant waived the right to appeal entirely. That's huge. No second bite at the apple. Add to that the firearm prohibition. Under Texas law, possessing even certain devices classified as firearms or ammunition could land him back in court with brand new charges. So ask yourself, was locking in certainty worth giving up every future legal option? Or would you have rolled the dice at trial?
Thank you, Ms. Simmons. I know. What? I know. See, Mr. Lewis on Mark Garcia. Yes, ma'am. Thank you so much.
Judge, I haven't seen him.
Okay, if you call the name Mark Garcia, please.
Last week,
He's
or late, he was late last week. So it wasn't Marvin had already left and you told him, I'm giving you 1 week to get here. I don't care what time you have to leave. Give him a lecture.
Driving in from
Houston.
Corpus or something? I don't know. I know. All right, his bond will be forfeited for non-appearance and reset at $100,000. Clifford Norman, Mr. Lewis. Oh, I don't see that paperwork yet.
Okay.
Clifford Norman.
I'm sorry, Judge, I haven't gotten to that.
Just have a seat. I'll recall it in just a minute.
He can come up and Mr. Norman.
What about Drayden Rose? Is there paperwork on him? I'll hold it. As soon as it comes through, I'll recall both of those. Mr. Kimler, you've got Ronald Souls.
He's trying to use the public judge.
And this is Ms. Malfino on Ronald Souls. Good morning, you're Ronald Souls. And in cause number 25, DCCR 0252, Mr. Souls, you're charged with unlawful possession of a firearm by felon. Case is set for trial to begin with jury selection on Monday, January 5th. What is the announcement?
Brady, Your Honor, I did file a motion to suppress, which I think we can carry with the trial. I don't know if it's going to show up yet. I did that over.
No, it's not here yet.
We can carry it with the trial.
Ms. Malfino.
I haven't seen it yet, but I'm ready. I just have one officer in that case.
It's just a warrantless, standard warrantless search.
All right, so I'm going to number the case. Obviously, everybody knows after today, no plea agreements unless something changes drastically with any information that you guys don't already have. Stay in touch with Mr. Kimler. You'll need to be back Monday the 5th at 1 o'clock. He'll know that for sure tomorrow, though, okay?
I think, Judge, if I may, there is a video, and I appreciate if the defendant would look at it before.
Have you seen the video?
No, ma'am, Your Honor. I wanted to bring this up to the court attention. I'm from Lake Charles, Calcasieu Parish. I don't know if the courthouse, that I'm not from down there. And
I don't care where you're from.
yes, ma'am,
I mean, I don't mean that mean, but it really doesn't matter.
This right here tells you everything about courtroom reality. Geography, excuses, personal inconvenience. None of it matters once a case is set for trial. The judge isn't being cruel, she's enforcing structure. Courts run on schedules, not sympathy. When defendants fail to appear, bonds get forfeited, warrants get issued, and numbers climb fast, sometimes to 6 figures. It's a reminder that once you're charged, compliance isn't optional. So let me ask you, do you think judges should show more flexibility for out-of-town defendants, or is this strict approach exactly what keeps the system from falling apart?
You've got Richard Robb. It's a sentencing, Mr. Kimler.
He's already pledged.
Richard Robb is set for sentencing. You should have a pre-sentence report.
Plus 3 days. Rob,
Oh,
sorry to
okay.
make sure I didn't mention that.
Oh, yeah, it was the lesser included. Okay. All right, sir, you're Richard Robb. And this is 24 DCCR 2170. Mr. Robb was previously here, entered a plea of guilty to the lesser offense of a Class A misdemeanor theft of property. And I reset it for sentencing. The agreement's for 3 days in jail. And is there any reason not to go forward with sentencing?
Now that I'm aware.
Not for the defense, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor theft of property, sentence you in accordance with that agreement to a term of 3 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been incarcerated on this case. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff. You've got Tajuan Mack.
Tajuan. Tajuan Matt.
Tajuan Mack. Do you need me to take a break, or are you good?
Tajuan, it should be. Brady. Gotta just, like, finish the case.
Transfer intent.
What did the jury think?
Notice lunch, China?
He's been here on every other occasion, so.
His
obviously
bond?
he's gonna be here.
His bond will be forfeited for non-appearance and reset at $100,000. If he gets here this morning during docket, I'll recall that. If we get him or he gets here, what is everyone's announcement? He's set for trial on the 5th.
State's ready for trial.
All right, it would be most likely the number 2 case and need to be, oh, he's a warrant as well? Okay. Well, we'll see. At least we'll know where he is if he gets arrested. Jason Harris, Mr. Kimler.
Yes, Your Honor. Oh, it's on, motion increase. It's a bond increase.
Good morning, you're Jason Anthony Harris, and this is 24 DCCR 2254. Mr. Harris's case is set for trial to begin with jury selection on the 5th also, and what is the announcement?
We're ready. Also, filed a motion to suppress over the weekend. We can carry. Well, it's probably haven't been accepted yet. We can carry it to trial.
Your Honor, the state's also filed a motion to increase the defendant's bond. He was apparently arrested back in August for, among other things, possession of drug paraphernalia. For whatever reason, it wasn't on my radar. I didn't see that. And in our motion, we were asking for an increase in the defendant's bond, or in the alternative, maybe a drug patch, and at a minimum, drug testing for today.
Have a seat in the jury box. Let's get you tested, and then we'll go from there on that. And Brianna Kleinan, it's a sentencing. Ms. Kleinan, before we go forward with you, I'm also going to have you tested. Have a seat in the jury box. Mr. Lewis on Clifford Norman. Good morning, sir. You're Clifford Norman. And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, yes.
Just a second. Mr. Norman, in cause number 25, DCCR 1034, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from July 15th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you would be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation, a $1,000 fine. You would be required to follow all of the rules and conditions of probation, which would include having no contact with a Kenneth Sweat. Do you understand? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I'm required to ask everyone. You understand that? Okay. State tenders number 1. It's admitted. Is there any evidence that Mr. Norman's not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That will give me more information about you and your case, and then we'll come back later for sentencing. Okay. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Okay. Yes, sir. All right, we'll see you back at sentencing.
All right, thanks. Thank you.
And then Drayden Rose, Mr. Lewis. Good morning. Are you Drayden Rose?
Yes, ma'am.
Excuse me. On a lesser, it looks like.
Yes, Judge. Lesser class.
So got it. Okay. All right, Mr. Rose, will he waive the formal reading of the indictment?
He does.
Mr. Rose, in cause number 25, DCCR 0789, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault from April 16th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 1-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And are you a U.S. citizen? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Rose is not competent?
No objection.
And Mr. Smith, since it's been reduced, is there any history or any reason to get a pre-sentence report? So, Mr. Rose, I'm going to waive the pre-sentence report in your case. I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm following the agreement that you made and deferring all proceedings and placing you on probation for 1 year. You're ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have the conviction on your record. And at the end of the probation period, if you are complete it satisfactorily, then the case will be dismissed. You'll never have that conviction. The other side of that is if you violate your probation, you can be brought back into court, found guilty of the offense, and go to the Jefferson County Jail for up to 1 year. Do you understand? I should have something. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. Once you get that, you'll just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. She's at that desk right over there, so be watching for her to call you up. All right, good luck to you, sir.
This defendant walked in hoping for closure. He walked out heading straight to prison, with sentences running together.
See, Mr. Burbank, you've got John Martin. Ms. Malfino on John Martin. Good morning, sir. You're John Martin. And this is 25 DCCR 0583. Mr. Martin is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
We're still waiting
On what?
on records.
Oh,
Yes, Judge, it looks like there was an agreed order for the CPS records.
back in October. Okay.
And I'll reach out to Ms. Adams. and
Okay,
find-
that would be great if you would see where they are in that process. We'll just do, let's do about 45 days reset, a little extra time. So hopefully we get those records back before then. You guys can review them and we'll see if we get an announcement. Stay in touch with Mr. Burbank and he'll let you know when you need to be back. All right.
This courtroom session shows the justice system in its most unfiltered form. Guilty pleas accepted, probation revoked, bonds forfeited, trials scheduled, and deferred probation used as both an opportunity and a warning. Some defendants walked away with a second chance. Others lost their freedom entirely. The judge followed the agreements exactly as presented, enforced waivers of appeal, and made it clear that accountability doesn't pause for excuses or delays. Every ruling here reinforces one truth. Once you enter an agreement in court, the consequences are real, immediate, and final. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and subscribe to Courtroom Focus for more jaw-dropping, no-nonsense courtroom breakdowns.